Hello everyone, this is Rishabh Singh. I'm a legal intern at LEXIS and Company. Today the topic of discussion is e-courts pressing priority in COVID-19 situation. A pandemic can be halted, yet one can arm themselves with its information and readiness. The pandemic of COVID-19 has seriously influenced the working of different business exercises across the globe. It has without a doubt caused a financial downturn and different calamities in the health and industrial sector. It has also made a worldwide pain in everyone's life circle, and the legal framework is likewise not an exemption for this. Unlike only a couple of months prior, the vision of virtual courts in India no longer appears to be a venturesome. The COVID-19 instigated lockdown of courts has given a kind of potential that innovations hold to address a key concern, that is admittance to the legal framework and accordingly the equity. So it has barred the legal framework. The courts over the country are closed and no hearings are being directed aside from the most appropriate ones. A few countries like Indonesia, Malaysia, United Kingdom, Singapore and numerous others have begun changing to online hearings and preliminaries, and it will be sensibly expected that India would not be lingering behind. The interruption brought about the pandemic basically forces us to move from a hammer to a tick. In India, evidently the crime percentage has dropped, and it very well may be the most ideal opportunity to clear at any rate and impressive accumulation of cases. The lockdown will just expand to deferral and equity liberation, and one push forwards the virtual becoming aware of cases will battle this postponement. So this lockdown period can be utilized by the judiciary of India as a chance to have more evolved court framework and overhaul the utilization of innovation in the legal framework. One of the ways for delivering some weight off the court is by setting up the virtual courts. Presently, the inquiry that comes as the main priority is what is a virtual court. So, virtual court is not quite the same as e-courts. As the name recommends, virtual courts are the courts that utilize a distant working framework with the assistance of different programming and programming. Its main aim is to wipe out the necessity of human presence in the court so that settling of cases doesn't get postponed because of the inaccessibility of the defendant or the plaintiff or the court staff. While e-courts are somewhat of a subset to virtual courts, as they allude to the sites and parts utilized to help the working of the virtual courts. The sites have versatile application and are different from other programming that is utilized for the computerization of the general set of laws. India is moving towards the fulfillment of a framework where there would be no necessity to visit a court face to face. Indeed, it's not off base to say that we probably won't have these courts after all things considered. Virtual courts, whenever executed appropriately, will give time-bound and viable conveyance of equity to the residents of the country. Courts everywhere on the world are exchanging towards virtual courts with the assistance of different innovative improvements being made. Courts in Texas have likewise begun to hear criminal cases and proceedings with the legal procedures by means of video conferencing, so the prisoners don't need to go out from the prison to the court. To investigate and anticipate the extent of virtual courts in India, we ought to likewise notice the turn of events and status of these courts in different nations. This will assist us with understanding what will be the issues raised by the execution of web courts in India and how could such issues be settled. On 26 July 2019, Delhi's first virtual court was dispatched in Tis Hazari Court. From that point onward, on 17th August 2019, the Punjab and Haryana High Court presented the virtual court at Faridabad, in which the court bargains in the rush are gridlock, Chalan instances of Haryana. this understanding was dispatched by the direction of the E-Board of the Trustees of the Supreme Court of India. The methodology followed here is straightforward and helpful, because the cases sum straightforwardly to the virtual court, which is managed by a metropolitan magistrate. At that point, a plea is created and accusant is told to denounce through email or SMS. At that point, the charge can go to the site, and assuming he concedes, the fine or sum will be shown. When the installation of this fine is made, the case will naturally be discarded. On the off chance that the blame needs to challenge the traffic challan, at the point the case will be managed by the regular court according to the regional board. The techniques help to facilitate the removal of cases, particularly in situations where the denounced before needed to visit the court in any event or confessing. This cycle likewise helps in decreasing the necessity of offline court. So the venture of e-courts was dispatched based on the Public Policy and Action Plan for Implementation of Information and Communication Technology in the Indian Judiciary 2005, which was presented by the E-Board of Supreme Court of India. Concluding that in the wake of dissecting everything in a exhaustive way, we can be guaranteed of the way that yes, every emergency brings another chance, a chance to create and redesign ourselves, a chance to make ourselves insusceptible to the issues and deterrents which may come in our manner later on. Comparative was the situation of things come of virtual courts in India. We prior brought up an issue, how far is the future? All things considered, we discovered the appropriate response. It's alright to say that the rough estimate would be 1 to 2 additional years, and we can see a grounded working arrangement of virtual courts in our country. Nonetheless, this can be accomplished just in the events that we remembered, the deterrents which are in our manner, and how can we eliminate them. The motivation behind why India is not yet having an undeniable arrangement of virtual courts is a result of different provisions that exist in the execution technique. It was tracked down that different region of the subordinate courts were not refreshing the national judicial data grid, which is the NJ DG, which invalidates the point of having a responsibility in the working of the legal arrangement of the country. So with this, we come to an end of this topic. Thank you so much.